Hello and welcome back to the One Take Show podcast. This is the 100th episode of the podcast, and I can't tell you, this is one of the most rewarding experiences of my life. I've spoken to so many guests, so many experts, so many seniors. I've brought their stories, their experiences to you, and personally, I've gained so much. I've learned so much. And what better way to celebrate this 100th episode mark but to have a conversation with one of the finest guests of the podcast, none other than Mr. Bharat Chugh. Sir is formerly a judge, was formerly a partner at L&L Partners, and is currently practicing as an independent counsel in New Delhi. In this episode, we talk about Litigation 101. And that's about it. That's all the introduction I'm going to give you, because every minute of this episode is a gem in itself. We talk about so many different things that it is going to add to your perspective, to your values in indefinite amount of ways. So please do watch this episode in entirety. More so, if you like this episode, which I'm sure you will, make sure you like, share and subscribe to the channel. If you have any suggestions or feedbacks, write them down in the comment section. I would love to read them. So ladies and gentlemen, without further ado, let's start the podcast.
You want something, go get it. Period.
Hello, so welcome to the 100th episode of the One Take Show. I, in no words possible, can convey how happy, how grateful I am to have you on the podcast once again, and to actually have the opportunity to host this conversation, bring this conversation to every law student. I think it is at this point when this podcast has really reached its purpose and has realized everything that it stood for. So thank you so much for joining me for this conversation.
Thank you so much for having me, Kaustav. Really enjoyed the last conversation that we had, and I'm glad we are following up on it.
Absolutely, sir. And I think before we start with this conversation, there is so much that I want to really learn from you. And I'm sure, like, if we start going down that rabbit hole, I wouldn't stop because I have so many questions to ask. But before we get into all of that, I just want to convey from every law student's perspective, there is a sense of like a tremendous amount of inspiration that flows. We really look up to you and we really adore you, your literature, the writings, the education, your guidance, and your constant presence in our lives in one way or the other, through your LinkedIn posts or your blog posts. I just want to thank you for that, and I hope that you're aware of it. It gets conveyed to you. But in that context, sir, how do you see yourself when you put yourself in that position? Do you see your journey inspiring to other people, and how does that reflect to you personally and professionally?
Uh, Kaustav, that's, I mean, you're very kind. You've always been. And I think I've always gotten more than my due from my peers, my colleagues, my seniors, and my interns at the chamber, people that I've worked with, first as a judge, then as somebody who's a lawyer at the firm, even otherwise. I don't think I'm worthy of this. But again, uh, I love to share the little that I know. It's been an interesting journey. The last 9 years that I've spent at the bar, um, again, have had the occasion of looking at litigation and courts, from a number of different perspectives, and just like to share the little that I know. And I personally feel there is this huge vacuum where we are just not doing enough. The college education, even with the best intentions, great professors and everything, it's just not bridging that gap between what is needed in terms of the practice of law and what we read, or in terms of what does it take to be a judge and what we read at college. And this is the vacuum that needs to be filled in some capacity or the other, or in some form or the other. I've, over the last 1.5 years, with courts only hearing the most urgent matters, and me not spending a lot of time, getting from one court to the other or one city to the other, I've tried to fill that in with my engagements with the younger law students, younger lawyers from across the country. And just to talk about judgeship, just talk about what does it take to be a judge, what do you do when you become a judge, try and help people prepare for the exam, try and help people who've become judges be sort of better judges, moving from what I call mere judging to justicing. Equally, for my young friends at the bar, helping them understand the softer aspects of advocacy, like cross-examination, talking to a client, briefing a senior, making a briefing note, how do you distinguish a case law, how do you read a case law, head notes versus a judgment, ratio versus obiter, these finer things which are somehow, we missed out in law college for whatever reason. Maybe we weren't sincere enough. But we did miss out on those. And the idea is to bridge that. Uh, and all the love and affection that I've gotten over the last few years, I find myself thoroughly undeserving. But again, it motivates me to sort of keep reading, keep try, learning of newer areas of law and communicating them to the younger generation. And now suddenly this makes me feel like 100 years old. Communicated to the younger generation, in a manner which is understandable, interesting, concise, and it actually makes sense for them. And in the process of this engagement, I've been more benefited, I think, by the younger people that I've engaged with, because each time I revisit an area of law, in order to put it simply, I force myself to think more clearly. I force myself to understand it better, because that's the only way I can communicate. And this engagement of a classroom, whether it's through a webinar or a course or an engagement such as this, has helped me sort of be better in the courtroom. And then the courtroom learning has sort of reinforced what I do, whether through a blog post or a column or a webinar. So I think in the end, I've personally benefited far more than any of my advisors may have benefited the younger members.
Right, sir. Because from this end of this conversation, although you say that you feel very old, from the legal age you're fairly young, and to have that level of understanding and to have that level of following, because I can say this for as a matter of fact that we all look up to you for everything that there is to follow. We try to craft our imagination of what a career in law would look like by following your footsteps. And when it comes to that, I think one of the first prime examples of when we all started following you, at least I genuinely started taking interest, was when we came across Justice Muralidhar's mention of your poem. And I know, like, we've spoken about your experience as a judge, and I won't want to reiterate that once again, but that one moment should have been very, very precious for you as well, when that was celebrated, a tea seller and a judge as a poem, going viral and creating that kind of impact in the judiciary as well. What was that moment like for you, sir?
Oh, it was phenomenal. I mean, I passed those orders or wrote those poems back when I was a judge. 20, I think I must be 24 or 25. At that moment, the idea, of course, was to sort of help out as many people as one could, be sensitive, be compassionate, be the change that I wanted to see in the world. And so that was the spirit of the order, and the spirit of judgeship for me. Then, of course, I decided to come back to the practice of law, because this was very dear to me, advocacy. This was what I identified, that this is who I am. And then, when I was serving as a partner at Luthra, I think Justice Muralidhar was kind enough to mention the poem in one of the lectures that he was taking on legal aid or social justice issues and sensitivity. And that sort of captured the imagination of a lot of people. And that was quite overwhelming, because Justice Muralidhar is somebody that we've all looked up to in law and in life, for his judgments, for his sensitivity. With he certainly leads by example, one of the most illustrious judges we've had. So it was a big moment, being recognized by somebody that I've looked up to. And but the best part for me about the whole episode around the tea seller and the judge was that a lot of people from across the country, young judges, for example, sitting in Trivandrum or sitting in Kashmir, took a leaf out of that poem or from that thought process. And they said, we've passed similar orders in slightly different scenario. We've let somebody get out on the defense of necessity. And so the conversation that it led to on judging and justicing and being more compassionate, that was amazing. And I still, and a lot of people started looking at judgeship in a different way. Many people wrote to me saying that they want to be judges because they also want to make a difference, just like that. They want to be there, use their legal knowledge to actually make a difference, and that was the high point. And fantastic stuff.
Absolutely. So, in fact, recently it was Honorable Justice Chandrachud who made a reference that there are two structures of law that function in our country, one for the rich and one for the poor. And a conversation I was having with a friend of mine immediately shared a poem with me. And he said, "You're going to have a conversation with Sir. Please mention this poem and make a reference of it." Because it is still very relevant, even when we have a conversation about these things, how it is impacting us as a society. It's making very relevant. And so, very interesting thing that you mentioned, and I think you're the perfect person for me to ask, that now making an advent from working in a corporate law firm as a partner and serving as a partner, being a very different work culture, to moving towards becoming an independent advocate and practicing. This change must in itself have brought a different kind of an experience for you. What was this change like, and first, what actually inspired you to go ahead with it, and how has the process been like?
Sorry, great question. I've always wanted to be in court as much as I could. That's how a litigator thinks. That's what a litigator wants from life, to be able to be in court, by a power of persuasion, convince a judge, do difficult matters, do socially relevant matters, do matters which make a difference to people's lives. So advocacy is something that I really like. I was appearing in a lot of cases even while I was at the firm. Even though I was in a firm, I was in the disputes team. So we were doing litigation. Most of it was corporate litigation, arbitration, white collar crime defenses, and so on. The idea to make a shift was motivated by actually a number of considerations. One was, of course, being in court more, which I get to do as an independent counsel. Work on a variety of issues. You're arguing a constitutional law matter on day one. In the afternoon you're doing an arbitration, then you're doing a trial. So the independence that being on your own means is something that's always fascinated me. I think being on my own, I also I mean, a lot of my time is spent engaging in teaching or writing. Being on one's own, it's easier to sort of manage your time that way. You can run the ship the way that one wants to, although the firm's been extremely kind to me, got to work on some of the best matters there. But wanted to be in court a bit more, wanted to also have a very social dimension to how I practice law, because I've done a lot of commercial litigation from one side or the other. But at the same time, I wanted to do cases which actually mean for the last man or woman in the line, for the common man, socially relevant issues, policy related issues, pro bono matters. We've been doing a lot of those lately. That's what you get to do when you're on your own, and when you do not have the other economic considerations largely at play. So that was one of the reasons. Also, was another reason was to uh, just, I think, do different kinds of work and not be constrained in any sense with the diversity that you can deal with, and to also explore whether you can be a generalist lawyer where you can argue constitutional law, a SFIO criminal trial, a technology intermediary related matter, or a service matter all on the same day, or is it something that you just can't, and you have to super specialize? So it was also an experiment for me in that sense. A lot of young people ask me, is generalization the way to go, or do you super specialize? What's better? What's commercially more lucrative? What is better for your own growth? And I always fall on the side of being a generalist, where your understanding of so many disciplines adds so much to how you strategize on a case, adds so much to how you present arguments, adds so much to your outlook and your understanding of the world as it stands. So I think being an independent counsel where you're briefed by counsels from across the country on a variety of matters helps me grow more intellectually, be more fulfilled in terms of what I'm giving back to the society, possibly contribute more time to pro bono and teaching, whether it is at academies or informal discussions with students. And I feel more free that way now, and never a dull day or never a day of regret ever since.
Right, sir. And I think this is very appropriate for all the law students who are interested in disputes in general, because there is a juxtaposition where they have to make a choice between practicing these disputes in a law firm or joining an independent chamber and practicing the hardcore litigation in the courts through via trial courts, or and then subsequently moving on to the higher courts. So if I were to ask you that, is there a way for me to conceptualize the difference or a change in the work style or the work culture between working in a disputes team in a law firm, in a top tier law firm, and then working in an independent chamber where there is a rather broader generalization, as you suggest. How can we sort of make up our mind while deciding between these two different worlds of the practice?
That's a great question. Things are, of course, done differently, when you're in a law firm and when you are in individual chamber. For instance, the matters that come to a tier one law firm would be usually very, very high stake matters. Those matters would be very, very document intensive. So you would have a case where the documents run into 100,000 pages. There would be many, many associates working on a single matter. There would be associates, senior associates, principal associate, partners, equity partners working on the same matter. And then there would be external senior counsels who you would be engaging with on strategy, on settling of drafts, of arguments in the court. And so that's the kind of matter that comes to a law firm, which requires a number of hands. You'll have teams of 15 lawyers working on a single matter, and there would be times when they are doing nothing but working on that one matter for 1 year or 1.5 years. Right? There are a lot of useful skills that you gather in that process on working on very big and complicated matters. Your research, document management, those get sharpened. You get to engage with the best people in the business in terms of minds. So when you're, for example, briefing a senior counsel, if it's a very big stake matter, you would normally have the best legal minds in the country on your side or the other side. Engaging with them is quite an experience. The way they look at law, the way they articulate, the way they strategize. Very, very good skills to have. You also get a very robust understanding of how finances and businesses work, because most of your clients are going to be corporates. You'll be dealing with in-house counsels. You normally would not be dealing with the individual client. So you would get an understanding of how corporations take their litigation decisions. How do they approach litigation? How do they litigate or not litigate? So all of those things. You also, since for example, you're dealing with a lot of international lawyers on some matters, you get to understand different cultures. You get to understand different, legal system differences. For example, there was a arbitration that we were working on where we had lawyers from 6 jurisdictions sitting on the same table, arbitrators from 3 different jurisdictions and legal systems. Somebody is a common law, somebody is civil law, somebody is an inquisitorial system. And some of the best law firms in the world got together on some of those matters. There is a certain amount of learning there. But again, everything has an opportunity cost, right? If you're working on those, what are you missing out on? You're missing out on diversity. You're missing out on dealing with a variety of clients. You're missing out on rubbing shoulders with clerks in the registry, clearing objections, some of the very useful skills to be having for you to litigate. And you also miss out on volume, because you sometimes feel like a very small cog in a giant wheel of a litigation when you're on a corporate firm, especially when you're starting off as an associate. In a smaller chamber where you are yourself doing some of the matters or playing a bigger role in some of the smaller terms matters, that gives you more responsibility, that gives you more face time in the court, that gives you the sense of being independent, the sense of being able to do things on your own. So there are opportunity costs for everything. I personally think that if the dream is to be a counsel in court and to be the voice of your client and not just a solicitor who's preparing the case as opposed to a barrister. I mean, we don't have the discussion in India mostly, but again, a law firm essentially prepares the case and then a senior counsel comes and argues it in the court. It depends on where you want to be. It would be a lot more hustle in litigation and in chambers, of course, than a law firm. A law firm is a relatively more secure place financially, in terms of your CV. It's a more sophisticated way of doing it, for want of a better term. But if you're doing it in a chamber, you're actually more hands-on. So it depends on what you do. At what point of life are you in? For example, if somebody who's looking for more financial security, you have an education loan to pay, and there are other considerations. Join a firm. But if the idea is to be in court more, I think it's better to join a chambers which has diversity, which has volume, where you get to do things, where you start taking up your own matters alongside your seniors and start taking responsibility for those. If the idea is to be in court, this is a better path for me, at least for the newcomer. For example, if you've climbed up the ranks and you become a partner at a law firm, then of course you get to argue more. You get to, do more on your own, strategize and build things. But in the first few years, you would or you may sometimes find a work a bit monotonous and repetitive, although the life at a chamber may look to be more interesting that way, although it may be less money. So one has to do that balancing depending on one's circumstances and take the call. I would personally advise, youngsters to start off with chambers if they're serious about being counsel.
Right, sir. Wonderful. Because this becomes so relevant when we sort of make a choice, especially for all the people who are first generation lawyers. The litigation becomes a challenge because it, as you said, does not provide us that kind of a financial security that a firm practice would. And one of those major reasons is because not all of us are very well aware of as to how to tap into the opportunities that could get us more sort of an economic or a financial awareness. Because one idea is obviously being a generalist, tap into any case or any matter that comes your way and go about it. Or the other idea is to become a specialist in one field and pursue that one field, and then make your name in that field, and automatically the matters will flow towards you. So is it better that we find a more suitable or a more structured atmosphere to groom ourselves in that position, or to jump into a chamber and get whatever a mentor provides us to, and then learn through the process and forget about the economic security?
Yeah, I would I would be the last person to say forget about the economic security or insecurity, because I've seen these challenges uh, for most of my life. I mean, till I was 21 years, we were staying in a one room flat, all of my family, and I didn't have a place to study. We didn't know how we'll make rent. That was the uncertainty during which I was preparing for the judicial services exam. So I didn't know if I'll make it or not. And if I don't, what would I do? I have a huge gap on my CV. I don't come from a national law school. Maybe the law firms are not going to entertain me and so on. So I know, what economic insecurity is and the toll it can take on your mental health, on your psyche, and all of that. So I won't say forget about it. I'm just saying that if you can manage with less, then the focus initially should be to invest in yourself. Law is a marathon, it's not a sprint. You may not get the results quickly. That's unfortunately the nature of the beast. What do you do about it? You may not get returns quickly, but you're learning. The kind of experience that you are having is all going to pay you, many, many times over. But that would take some time. The idea is to be at it. If, for example, your economic insecurity is dire, then of course take the first thing that you get, which gives you that financial security. You can always come back to litigation once you've repaid your loan or given some semblance of a financial security to your family. You can always come back to litigation. So it's never too late. Decide. I personally would think on the question of journalist versus specialist. Don't try to super specialize for at least the first 3, 4, 5 years. Economically, it may be very lucrative. You may carve out a name for yourself as being a tax practitioner, a GST practitioner. But at the end of the day, the GST provisions are tested where? Tested at the anvil of the Constitution, right? And with how interconnected everything is, it's good to sort of give time to different kinds of disputes the first few years. And then maybe, and once you've done that with 7, 8 years or 10 years or 15 years of committed learning, and not just learning on law, reading in life, and trying to uh, being a seeker, trying to know things more and more about this world, even if that means trying to know something about everything instead of everything about something, but then that also gives you a perspective. And lawyering is about perspective. Lawyering is not about digging a trench that is deeper and deeper and deeper, because once you super specialize, you've dug a trench that is so deep that you can't get out of it. Maybe you super specialize in an area which becomes redundant tomorrow. What do you do then? Then you'll have to reinvent yourself after 8 years, right? I mean, what winding up used to be, IBC's changed the game. Many legal areas become redundant and new things come up, and then you have to reinvent. You can do that really well if you know the general fundamentals really well and you've done a variety of different things. So don't dig that trench so deep that it's difficult for you to step out. Try, and it's also diversifying risk in that sense. You never put all your eggs in one basket. So try, but don't spread yourself too thin again, because a person who would come to you, for instance, with a service matter, expects you to know that. And you'll be doing your client a huge disservice if you've just taken it up for experience. That's not fair to the client, right? Then you'll have to burn midnight oil. You'll have to cut down on your sleep in that sense, because you have to do justice on that matter too. So ultimately, if you're working hard, you'll be able to find the right balance on what is working for you, whether you are growing or not. We all get to know if you're intellectually growing or we are stagnating, and then we start looking. So whenever that happens to you, take a step back, re-examine, and looking at the long term always helps.
Absolutely, sir. I think this reminds me of a wonderful post of yours where you talk about learning from the University of Life and having that broader sense of perspectives that we keep gathering, and how that is so useful for every litigator. Because just for all the viewers who happen to not follow you for some reason, I don't understand. They must be aware that there is a series you started. It was Litigation 101, and it's absolutely wonderful. All the posts around it was also something that was absolutely out of the mark, giving us all the important perspectives. So, when you talk about learning from the University of Life, and when it comes to the value that it brings to a litigator's career, or professionally, personally, how important is it that we be aware of what is happening around us to build that level of awareness, commercial awareness, or awareness about the interpersonal skills, or anything that we can learn from the University of Life?
I think that's the only way to sort of learn law, with how inextricably it is connected with people. These are human lives. A client is here. You need EQ to sort of talk to the client, get the client to trust you. You need EQ to sort of stand in the court and develop a rapport with the judge, where the judge begins to trust you. The judge does not see you as a guy who's slimy and who's misleading the court. In a different court where you've never appeared, or a foreign tribunal, you need to create that confidence. That will only happen when you understand people, that you're compassionate and sensitive. Uh, so that's and this is not something that a book can tell you. This can only happen if you keenly observe people around you, if you engage with them as human beings, and if you think, I think, more than anything else, uh, reading extensively and widely about psychology, sociology, history, all of that. I can't emphasize this enough. We as young people, and I like to include myself in that bracket now. We haven't lived enough. Our lived realities are not enough. So what we need to do is we need to borrow from the masters. We need to vicariously live through the books. And if you can live a couple of lifetimes and learn those skills, what to do, what not to do. For example, a Chinese, warfare expert can tell you a lot about litigation, can tell you a lot about cross-examination in the art of warfare, in the art of war. So you need to draw from those. Chanakya can tell you about cross-examination if you look at it in the right way. So just keep an open mind, have that hunger to know, and again, you made a very good point about, if you have a client who's a corporation, they want to make a decision whether to arbitrate or not, or litigate or not. There is obviously a economic decision behind it. They would do a cost benefit analysis. If you're not there with your client on the cost benefit analysis, for example, if you advise and they indulge into a misadventure of a litigation where they end up losing a lot of money, or the gains are not commensurate with the risk that they are taking, and you don't understand that those finances or that business thinking behind it, you would not be able to be the trusted advisor for your client, or you would be able to advise them effectively. So important for you to just get out of your own skin and think like the other man, whether it's a judge, it's a client, it's a witness, it's a co-counsel, it's your own colleagues, it's your own interns, it's your own students. It's just about that. And of course, I mean, I'm not against conventional education, let me not be mistaken. Although I love to call myself, as somebody said, a scholar on the road instead of a road scholar. So that's how I've learned to learn law and life. Study is important, academia is important, but taking a step back from the books, thinking about it, giving it a practical dimension is extremely important. Yeah.
Right, sir. Because at the end of the day, does it translate into real life or not is also a big question. You mentioned that a lot of litigators who get into the practice imagine themselves of being those illustrious lawyers or argumentative, those arguing counsels who get into the courtroom and just fluster the judges, and there's an applause all around. And then you use a very interesting phrase, which is, and I've noted it down, well laid out schemes of mice and men. And you summarize how the reality check is something that dawns upon these lawyers, these advocates, the young advocates, and how they need to adapt to it. Do you think it's important that we, apart from having that experience through internships, or having that experience through actually going through the argumentation in the initial years, how important is it that we prepare ourselves for such situations and to have a better understanding to match our ideal situation with the real situation?
It's a great question. I think that can be bridged by, number one, again, reading as much. A lot of learning in law happens through osmosis, by just looking at people, just being in the court, looking at people, open a case terribly or open a case beautifully, or responding to how the judge is responding, in a certain sensitive way, where you're sort of you can anticipate what the judge is going to ask less. You can see what are the questions that a judge can possibly have on a brief like this. There have been cases where we've stood up in court and the judge thrown my brief before I could walk to the dais, and I told the judge that this is exactly what I did when the client came to me. I also threw the file. I don't think he has a case. But then I turned to page 49. My lord scan for a moment. When he picked up the file again.
Right.
That's what you do, because I anticipated that this on the face of it was purely hopeless case. But then, and if I started fighting with the judge, or if I started taking this as a personal affront, how can you throw the file? You haven't heard me. That's never going to work in a court. That guy is not your enemy. That both of you are driven towards one objective, that is to find justice in a case. So align yourself with that individual who's called the judge, and just try to find common ground and empathize and visualize what he's going to ask. So just to come down to the question, this question is about visualization. As a young lawyer, I used to walk into the court with a script ready, with case laws, with rhetorical flourishes, with a quick turn of wit, and I would be really disappointed because I wouldn't get an opportunity to do all of that. The judge would cut me out at some point along the spectrum, depending on the patience in the judge, and I would be extremely disappointed. And that is why it's very important to sort of be your own worst critic, I think, or your best critic. There's this phrase in creative writing that one uses. It's called kill your darling. Sometimes you fall in love with a phrase. Sometimes you fall in love with your own argument, your own voice a little too much. The idea is to not be afraid to take it out and amputate it, and look at everything that you are doing extremely critically. That's the only way to do it, because even if you don't, the judge is going to look at it critically. The opposite side is going to look at it critically. Why not battle it out so well within your chambers, within your mind, that you are not leaving any situations unseen? Lot of it would come through time. Don't think it's going to happen just because you sit in a dark room with Beethoven on and you're focusing very hard on the brief and you'll come up with all the answers. No, some of it would only happen once you've been through those situations, once you have those patterns in your head. You have to experience, right? Some things. So things would happen slowly, but the importance of thinking, is very, very important. And don't be too self-indulgent. Sometimes as young people, we are too self-indulgent, we fall in love with ourselves too much. But as we, sort of, there's too much idealism also, which is a good thing. But then we grow up and we start looking at things more objectively. We hear other people too. We become critical of ourselves. I think as long as you're questioning everything, as long as you're not taking anything in a state of willing suspension of disbelief, you're good and you're ready. And we try to do that in the chamber, and sometimes my colleagues hate me for it because of how deeply we analyze and how deeply we sort of fight it out. Even at the firm, we would love to do moot courts, before we go to court, where we would have different sides taking up different arguments just to be the devil's advocate and try to test ourselves before we get tested in the court. So those are important exercises. Do as much as you can of those. Thinking about the brief, visualizing is very, very important, but not done enough, I feel, by people across the board.
Right, sir. But there's something interesting you mentioned, thinking about a brief, and you've also mentioned it in one of your posts regarding Litigation 101. What exactly is it that you mean by thinking about a brief? Is it the imagination of all possible outcomes or all possible scenarios that can go down in a courtroom? Or is it that you formulate different plans and different alternate strategies that can be undertaken? Or is it that you make a choice, strategic commercial choice, or whether we want to go ahead with this step or not? And then you think about, because this experience that I've had, very limited one, of observing senior counsels, not really thinking much about or spending a lot of time on the laws, but spending a lot of time on facts and how it is going to go down in the court and how it is to be perceived by a certain judge or a certain bench at a particular point of time. So, is that what this interpretation is about?
So it's actually a bit of all of what you mentioned. Number one, I think, is of course reading it really well, knowing those facts. You should know. Then I think when the thinking part comes in, you visualize first of all. You become the party, you become the claimant, you become the defendant, and then you switch roles also. Then you become the claimant also. You live. You try and envisage. What must have happened. What was the intent? Why did they write this? If you're interpreting a contract, go back to the time when they were negotiating that contract. What would have happened? What was the tension in the room like? And then see, what does this clause mean? What was the background to this clause? How was the company doing at that point? What was the need of this clause? Who were negotiating on either party's side? What kind of lawyers? What kind of in-house teams? It's about that visualization. It's about becoming a party, number one. And when I say become a party, I'm not saying that become emotional or become emotionally connected to your brief, that you are angry and it leads to you becoming too involved. Not that. Just visualize and think like the parties would, and all the parties, number of different perspectives, as you said. And there may be many perspectives. In a criminal matter, there may be the prosecutor, the society, the victim, the immediate victim, the accused, the judge, the probation officer. There may be n number of ways you can look at it, and that is where you would be able to choose what works in a given situation. One perspective may work, and then the other may work. Spend time with it. Most briefs are going to take time to seep in. Sometimes you would read it, you'll wake up with an idea the next morning or 2 days after you've read it. Give things time. You are as good as your last performance in the court. Court is a great equalizer. We may say that we've done this, we've done that, but ultimately what we do there is what really counts. So you need to do all of this thinking to maintain that quality, to maintain that mastery over the matter, where nothing surprises you. I think the ideal situation would be if I go into a matter and there is no question, no fact, no situation that I haven't foreseen. And that's what the best people in the business do. They acquire it by having done so many. For example, if you've done 20,000 appeals, you know those situations, right? The difficulty with younger people is that, and that is the reason, people say, okay, let's go in for a more senior counsel or go for a senior doctor, because he's identified more patterns and he's more attuned. Uska instinct be developed hai. He can possibly make things out at the first blush and do a prognosis. But a younger person hasn't seen those patterns. So you'll have to read, you'll have to think doubly hard, speak to as many seniors as you can on a given situation, anonymizing the facts. Ask different people, different aspects of the case. Please ask people to weigh in. It's very helpful profession in a lot of ways, where people can tell you from their experience. Because if you've acquired 20 different perspectives on a matter, you are very good to go, and the problem is being too much in your own head as far as litigation is concerned. I'm sorry, the conversation is turning out to be too psychological in that sense, or philosophical, but this is quite important. And I mean, whatever all that you said is important, and that is what I mean by thinking about the brief. And when I say thinking about the brief, law is extremely important too. I mean, you should not try to go to court unless you read all the case laws that oppose you, right? Those are more important than the ones that support you. I see cherry picking. I see paras being relied upon without understanding of the context. I see statute provision being relied upon in a bare act without looking at what the chapter heading is, what the marginal note is, what the statement of objects is, what the non-obstante is. So all of these things are interrelated. And if you're thinking about the law and this, and the only way to do it really well is to love it. Unless you're passionate about it, you would find this tedious to do. You would find yourself distracted all the time. So the idea is to sort of love it and find a lot of joy in solving a legal problem. And once you find that joy, this thinking about the brief that I keep harping on is not going to be as problematic.
Right.
Sorry for that very, very long meandering answer.
No, sir. Sir, I wanted to make this episode unique because obviously there is so much that has been written and spoken about you that it's very difficult for me to sort of garner an episode or a structure of episode that is very unique for our audience. But I think I'm successful. We as this episode is becoming slightly successful in that front. We're having some really interesting conversation. One thing that you mentioned, sir, is very interesting because when we talk about this envisioning of what can go down and what cannot, there must be a lot of briefs that come to you, and there is a sense of drafting that reflects that level of storytelling, because at the end of the day, I think dispute resolution essentially comes from a very innate sense of love for storytelling, and it is the understanding and interpretation of the same. How do you think, because this is also one of the things that you mentioned in one of your posts, that how does this real unique sense of drafting can be learned by anyone? Is it a skill that can be acquired, and if it is so, how is it that can be acquired?
That's a great question. I think one of the ways in which you can tell a better story is to read a lot of stories, right? And then look at the master storytellers and how they do it, how they grab you by the collar and make you sit and read, right? I'm not saying that you make your writings very very literary or very very flowery, or not that. The idea, of course, is at all times going to be communicating. That is why you write a brief. That is why you write a judgment. That is why you write a legal opinion. The idea is to have a conversation. There are certain formalities that are there in drafting, but those formalities and legal requirements do not take away the storytelling element, according to me. For instance, the CPC is going to tell you that you need to state the material facts. Now, that's very good. That's what you do in good storytelling. You tell only material facts. You would not disclose the evidence by which you have to prove a fact. You would only state the material fact. Evidence can come in later. Fair enough. That doesn't take away communicating at all. So these are things which you need to keep in mind. If you read a lot, you will know what are the different ways of telling a story, right? Obviously, you're not going to go into magical realism. You're not going to go into 17th century English. The idea would be to communicate plainly what happened, right? There are various instruments of doing it. For example, uh, one formula is who did what to whom. Every paragraph should reflect who did what to whom. When you are writing, sometimes drafting pleadings, you put questions to yourself and then you go on to answer them. That's another good way of writing. Chronology, precision, never use two words where one would do. The shortest distance between 2 points is a straight line. Be straight. For Hemingway used to possibly write like that, where he would have a certain economy with words, where he would not use two words when he can do with one. And that's important for drafting too. I see, things just being replicated. Sometimes jargon is seen as a sign of intellectual merit and caliber. It's not. Latin maxims, other arcane phrases. I've been guilty of it too, in my younger days, where if I could make something abstract, I thought of it as an intellectual achievement, but it is not. I think favoring the concrete over the abstract is the real achievement. Being able to put something very complex and nuanced in simpler words is the real achievement. That would only happen when you read a lot and you write a lot. You'd have to also explore writing outside of pleadings, for you to know how to put an idea in a compressed format, for you to think more clearly. And again, I keep saying this, and this is where my literary hero George Orwell sort of comes in, where he says that clear writing is indistinguishable from clear thinking. You can't hope to write clearly or write better, whether it's pleadings or articles, unless you think clearly. And if you're thinking sloppily, you're writing sloppily, and if you're writing sloppily, you're thinking sloppily. There's a vicious circle. So focus is read as much, write a lot. Of course, think a lot before you write. I think more than anything else, our drafting is the way that it is in most situations because of us not putting enough time to it. You reproduce what's already there in some pleading. Thoda sa idhar se liya, thoda sa udhar se liya, kuch bana diya. No, there are people I know who draft pleadings when they read everything and then they don't look at a file. Then they dictate. Because they've internalized the fact so well. And that is the way they're able to put it in the least number of words. When you're doing copy paste, then of course you'll end up writing clumsily. I tried doing that when I used to write judgment, where I wouldn't look at the file, where I wouldn't look at the complaint, where I wouldn't look at the defense. I would just, and those were my most pithy judgments, because I'm dictating or I'm typing. I don't want to waste words. And that also ensured I understood the facts really well. And I acquired that mastery because I was not relying on the plate to take the facts from. I knew them. So putting in the necessary time, the problem is some people are trying to do too much in too lesser time. Sometimes the chamber is overworked. Sometimes there's just timelines, and then quantity takes over quality. But again, the judge is going to know you by the one brief that you file before him, right? It's your chance to shine. No other case matters. You may have done 19 other things well, but if you're not good with your plaint, or if you're not good with your briefing, that's the only thing that matters in the moment. Seniors should also understand that, and portion work in that way, where a young lawyer can actually give the time that briefing deserves or pleading deserves. And pleadings used to be, again, sounding like an old man. Pleadings used to be so pithy back in the day. When I used to read, I was a civil judge at Tisadari. I would read a plaint of 25 years old, and I would see how beautiful the writing is, because work was less. People could spend time drafting and articulating. And then I would look at pleadings or a plaint running into 100, 150 pages, all cut copy paste. So technologies hasn't helped, and we wanting to do too much hasn't helped. But again, you can't be a better writer without being a better reader, a better thinker, or giving a brief the time and attention that it deserves.
Wonderful, sir. I think I could just listen to this own segment of this conversation on a loop just to internalize this, because obviously this is something that is so important. And I remember from our previous conversation, I remember you telling this very clearly, that for any law student, your advice is to write, because if you write, you have a clarity of mind, and that flows through your ability to articulate your words and your thoughts, and it's very important. So when we talk about learning all of these things, and obviously, like, I would want to believe that my podcast helps a lot of people, and it surely does help me as well. But there is a very indispensable need of a mentor for any fresh lawyer who enters the industry, a young lawyer who enters the industry. Is there a way that we can identify a mentor or find a mentor and reach out to a mentor as and when we find them? And if we do, how do we recognize and hold on to that mentor so we can stick with them and learn from them?
That's a great question, Kaustav. I think I would say there can be different mentors too. It need not be one person. It may be a teacher, it may be a senior, it may be a senior colleague at the chamber, it may be somebody that you've never met, that you followed and read from. Now, of course, information is so easily available. Everything is at the touch of a button, and easier to find mentors in that sense. For example, I'm able to connect to people sitting in the other part of the country, people I would have never met, never known, but I'm able to talk to them for what it's worth. So things are easier. But then again, there must be a caveat that this is a journey that is to be traversed alone. Solitude also has its very, very important role, because it's essentially meditative, the nature of the profession, right? You need to be really comfortable with yourself too. Of course, learning, looking up to people is good. And these may be people that you read about. That's fine. Another caveat, apart from not sort of losing your individuality, is about I think also testing your heroes, or people that you look up to really well. Never take anything without a pinch of salt from anyone. You in fact, you need to test heroes, test your people you look up to even more, and hold them to a higher standard, and work like that. And of course, with it's easier to find people now, and once you've found them, also wanting to extract, or how to extract is important, because there are some people who would be hard pressed on time. So you also need to respect their time. You need to sort of ask relevant questions, specific questions, so that you're utilizing their mind better. So being smart about it is very, very important. Just to give you a small example, there are people who write to me on an everyday basis, and dozens of people, well-meaning people, who write to me that we want guidance. Now the challenge for me is I can't, because I don't know where you come from. I don't know, what are your difficulties. I don't know what are your priorities, what are your likes, dislikes, and very difficult for me to have one-on-one conversations with all, right? But there would be somebody who would have already read what I've written on the subject or something that I've spoken on in a video, and now would have very pointed questions. I would find those easier to answer, and I would quickly, and I try to look at every email and message that I get and try to answer. So again, the way you seek help and how successfully you are able to get it is important. Learn to respect the senior's time, learn to respect a mentor's time, be more prepared, do your homework. It all boils down to, the sort of work that you're willing to put in. Because, there are people who had, read a judgment and tell me the facts when they are briefing me, didn't know what really happened. I'm also able to contribute, in that briefing, for instance. I'm able to utilize that time to share what I read, from US jurisprudence or from some other experience that I've had in my life. Why was I able to give that away in a briefing? Because people on the other side were more prepared. They could take more if they'd consider me a mentor from me. And I was happy to give more because I was getting from them and they were on top of it. So find a mentor and then do justice to somebody who's there to help.
Absolutely, sir. And I realize that I've already taken a lot of your time. I hope you forgive my impudence on this front. I just have two more questions, and I hope we can. I would try to wrap this up because definitely speaking with you, it's an honor, it's a privilege, and to have this opportunity, it's very easy to let go of it. But so my two questions are very specific with reference to all the students who are trying to uh, find a mentor in you, which they already do in one way or the other, but in a more direct capacity where they're trying to intern under your guidance, intern in your chamber. And there is a very interesting procedure that has been set out for you. It has been put up on your website as well, where you do not want a rundown application format that is copy pasted everywhere. It needs to be very specific. It needs to be unique. It does not need to have those very staple sample clauses or the words that are usually used. What was what was your reason behind using such a methodology for people applying as interns for your chamber?
Thanks for that question, Kaustav. A number of reasons. One is that one was administrative efficiency, of course, because we get a lot of applications for internship. It's just next to impossible to sort of make out uh, who do we want and filter through those. And if and that's what led me to think on the best way to do it. I didn't want to delegate this to others. And in any event, it's a small chamber, so we don't have a dedicated HR department. And I wanted to look at every application myself. And so I thought, why not get people to write to me in a way which gives me the maximum information about them, tells me if they have a right attitude. Aptitude is also there, but not as important as attitude, I would say, because it's the zeal to learn, it's the humility that we don't know enough and we want more, and and those basic values in place. And I think the present application format does help us, know people more intimately, and then see if our values align, and then we sort of work together. I've had fantastic applications, over the last few months after we introduced this format. There are people who've written to me saying that this was the first time we were having a conversation with ourselves because we had to write this application. This was the first time we sort of stopped to think, what are we doing? This was the first time we stopped to sort of just make sense of life. It was beautiful and great stories I got to know. Last few months have had great interns at the chambers, learned so much from them. And that's one. Second was also about diversity. It's about wanting to make this more inclusive, wanting to make this more accessible. Uh, as I say in the blog post, that the law college or the pedigree or the schooling, none of that matters. Uh, what matters is who you are, uh, and so that's the idea. And so this format helps us, make it more inclusive. Sometimes we make a conscious attempt to sort of have a more, the more gender parity in terms of men and women and whoever wants to come. It also helps us get people who've got nothing to do with law. So we've had people who are studying policy, studying philosophy, studying economics, wanting to intern. Why? Because they're excited about the interface of economy with law. And so we've sort of reached out to a wider audience and learned so much from them. So I think it's worked out well. And we've had people, who are not into law or who are going to join law just out of their 12th standard. And we have people who are practicing lawyers too, wanting to intern, because I would love to offer them a position as associates. But again, being a small chamber, we have those limitations. But such great diversity and cross fertilization of ideas we've been able to achieve through this method. And I hope it's not, too much of a ask that way. But yeah, it's been fun.
Right. So I think one wonderful thing that this application process does is that it democratizes the entire process, and it sort of allows us to explore our own individuality and be very curious about what is it and how is it that we can present ourselves. Something that we observe in the application process for the universities abroad and by a lot of other jurisdictions also celebrated. I think this is a very, very unique thing. And in addition to this question, I think the last question that I'm going to ask you is a rather very personal question that I also have been trying to find an answer to, because there is a very staple rundown advice that we always receive from everyone is to work hard. As a law student and as a fresh lawyer, you're supposed to work hard and you're supposed to be dedicated. But what does it mean to work hard, sir? Like, if someone is to work for you and you are if someone is to join your team, if someone is to join your chamber as a junior, and if that is expected of that person to work hard, what are the various aspects of the same that you would want that person to be aware of and include?
Great question again. I do not personally believe in the traditional binary of what's the hard work versus smart work. That's usually an easy thing to say and say, don't hard work, just smart work. I'm not getting into that because I don't understand that enough. Hard work is important, but then again, your efforts should not be misdirected. That's something I believe in. That would, of course, require you to take a step back from time to time and think yourself: is this the right direction? Is Should I be looking at other things? And there should be a logical approach or method of doing things, a method of research, method of looking at a case. Different people approach it differently. Uh, for my chamber, for instance, my colleagues, hard work means we get a case, we are excited about it. We want to learn something new. We want to contribute. We want to push the frontiers of law. We want to get the client justice. We want to do it fairly. We want to do it the right way. We want to learn law in the process. So we take up a case. We take it as an opportunity to learn the law. If we get a case on Land Acquisition Act, we would make it a point to read from section 1 till the end of the Land Acquisition Act, because this case is an opportunity for us to learn. We are extremely blessed that we get paid to learn that way and master a new area of law. So that if somebody's excited, I get excited today. If I get, arguing a cryptocurrency matter today, I get excited. I want to know everything about the science. I want to watch YouTube videos on it. I want to watch, I want to do a course on it if I can. And I'm interested in knowing it. So as long as people have that drive and that hunger and that pleasure of knowing things or pleasure of finding things out, you'll do well. You'll research appropriately. You'll try to find out answers. So that and a sense of ownership. Sense of ownership is very, very important. If it's your work product, you should take a certain amount of pride in it. And once you start taking pride in your work, start taking pride not in the negative sense, pride in the fact that this is my work. This has to be good. This has to be of a certain quality, because I stand for quality in life. Once you get to that and you have that self-respect and everything, then it works out well. Then you will work appropriately. Work would not become a chore for you. And if you are finding it interesting, then you won't mind also going the extra mile in that sense. And ultimately that's needed. There are no shortcuts here. Either you start to enjoy it, or you sort of find out alternative ways of leading life. So again, hard work, that childlike curiosity of finding out a new legal proposition or contributing, that's very, very important. Child is very sincere when he's playing with a toy. That kind of focus, that kind of joy is what you should find in your cases, and that's all we are looking for.
Wonderful, wonderful, sir. I think this is by far one of the most interesting, indulging conversations I've had, and not just on this podcast, by the way. by far one of the most interesting episodes. I think there is so much in this episode to unpack, and I understand I've taken a lot of your time, but I'm really, really grateful for it. I am really, really excited to bring this episode out for everyone to watch, to view, to listen, to learn from, because I truly believe that there has been a tremendous opportunity before us. All this technology has brought us closer to you, and in one way or the other, all of us are really getting benefited. We all are learning so much, and I am really excited. Before we wrap this up, sir, do you have any closing remarks for our viewers?
That's um, There's a lot of pressure on me to distill, what I think and sort of put it in a test of my own principles in that sense. I think the idea is to just love lawyer and be passionate about it, and it's going to it's going to be a very very good run that way. If you start loving it, and you'll be able to contribute much more. Don't leave things to luck. There's nothing known as luck. Seneca said it beautifully. Luck is the point where preparation meets opportunity. Keep preparing yourself. An opportunity would come. You strike it, both come together, and then there's beauty in that moment. So just sort of do that, and yeah, that's it. Thank you.
Wonderful, wonderful. Thank you so much, sir. I had a wonderful time. I hope you had a good time too. Thank you so much for joining
Had a
me.
great time. Thank you for having me.
Thank you so much, sir. Thank you.